Commissioner King, can you hear us?
Can hear you. Can you hear me?
Yep, we can. All right, perfect. We're going to get going here. As soon as Bailey hits record, we are. So I open up this meeting. Oh, is Jody on there? Okay. Open up this meeting for our formal session on February 5th at 10 a.m. And I'd ask Kevin to lead us in the Pledge of Allegiance. Allegiance to the flag of the United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you for that. Up next is our calendar session. Is there any changes?
No.
None for me.
Thank you. Up next is our public comment. This time period is reserved for public comment and on any topic other than an agenda item, a quasi judicial land use matter, or a topic scheduled for public hearing. Public comments will be limited to 3 minutes. I do have some already filled out. If anybody else would like to make a public comment, please fill out either a tan sheet for a general public comment or the green sheets for the public hearings coming up. And if you're online and would like to give public comment, make sure you raise your hand now. With that, the first one in order that I'm going to call up is Cynthia Palmatier. Name and address, please.
Okay. My name is Cynthia Palmatier, 5255 Southeast Lambert Street, Portland, Oregon. We are 4 members of our Article 3, 1 Supreme Court claiming original jurisdiction, Article 7, Amendment 7 Jure, Civilian Common Law Court of Record, having implemented Ex parte Milligan on Oregon. This is from Article 1, Section 1 of Oregon's Constitution. We declare that all men, when they form a social compact, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. We are here to petition for redress of grievances. This is a formal demand in living testimony. Proper oaths and bondability for all 36 sheriffs and their deputies on Oregon, among them is Sam Elliott, occupying the office of sheriff for Yamhill County. This formal demand is presented to the Yamhill County Commissioners for your records. ORS 206 DPSST, Yamhill County Human Resources, and Yamhill County Recorder all must be adhered to. We expect accountability from the county commissioners, some of whom we met with personally and our previous presentations here before you. Responsibility, authority, and accountability rest with the commissioners of our counties. They must hold their county sheriff and deputies responsible for knowing their constitutional obligations. They must know the difference between jure and de facto. They must know the difference between a pledge to the U.S. corporation versus a pledge to the people. They must know the United States of America and Oregon's Constitution, both circa 1859, defined by Bouvier's Law Dictionary, 6th edition. They must know the significance and difference of the illegal or illegitimate change made in Article 7, i.e. original versus amended in the Oregon Constitution. This should be considered a demand. I also would like to address with regards to our sheriffs, that we have a state gathering of sheriffs organization that happens once a year. And a couple of weeks ago, there was a national organization conference of sheriffs. And I just want to make a point that sheriffs belong to the people on each and every county. They don't belong to the federal government. And I know that they take an oath to the Constitution, and it should be the original Constitution, but they gather and as though they're a group, and they've honestly, I believe they've been federalized now, and they shouldn't be like that. They belong to the people of each and every one of these counties, and I yield. Thank you.
Thank you. I'm going to call up next Bobby Graves. Come on up and name and address, please.
I'm Robert Graves. They call me Bobby. I claim to be 12 years old. It's my story. I'm sticking with it.
What's your address, Bobby?
I live in Eugene, 1830 Grove Street in Eugene, but my family's from here and we founded this county. We're the first family here. That's right, when it was all called Yamahala, not Yamhill. My grandfather helped write the Constitution, 1857, finished in September. It took a long time to get the paperwork to Washington, but they finally did. So 59, Valentine's Day, we were in the Union as well. Two different processes. Becoming a state is one thing, being in the Union is another thing. Congress doesn't make states, people do. Now, I've talked to a lot of sheriffs. Now they won't let me in. Why? What's going on? Well, they think they have a legal counsel. Let's talk about that. They don't have any legal counsel. Anybody who belongs to the so-called Bar Association, and it's worldwide, by the way, I don't care what they call it locally, it's in every country on the planet, is a British organization. It has a temple. It's in the old city London in Westminster neighborhood, just one block off of Fleet Street. I know exactly where it is. It's called the Corporation. It's never been part of England, ever. It's owned by the Vatican. That's what's going on. So the sheriffs think they have a legal counsel, and as soon as I finish talking to them, and I've talked to a lot, their legal counsel says, oh, those guys are crazy, don't listen to them. Yeah, because they're British, and they've taken over the country, starting with the Civil War, when they came walking right in here in great numbers, and incorporated everything. That's how they take it over. When you make something incorporated, it's a legal fiction. That's not what the founders created here. The Republic is still here. It has never been removed, and it can't be. It's not a corporation. You can't bankrupt it and close it, like Lincoln did. Finally, the last one, of course, Franklin Roosevelt did, and reincorporated the working federal government, which is a service provider in commerce. It's not the government. It's supposed to be representing us as a service provider. That's why we had a constitution, to have a contract between the first 13 so that they could have somebody put them in commerce. No country on the planet can trade with us. We were a rogue nation, independent. Everybody else is incorporated. Commerce is only done by people who are incorporated. It's a closed process, legal fiction only. And we were not. We were sovereign on the land. That's what happened here. Britain wanted their colonies back. French wanted their colonies back. They created the Civil War. They planned it themselves. We wouldn't have known that except Russia was invited to the party and they blew the whistle and came in and protected us. That's what happened. So, who's the highest law enforcer in a county? The sheriff. We don't have one, 36 counties, not even one. And I spent 2 hours with Jackson County, and he understood. But as soon as I left, his Bar Association member told him, don't talk to these guys anymore.
Bobby, I'm going to have to ask you to wrap it up.
That's the problem. Be careful who you're listening to. Bar members have never studied American law. There's no credit given to it in any university in America. They
Appreciate it.
study the King's law.
Thank you.
Stay there too. I'm gonna yield my time to you. Thomas Siniscale, 4155 Northeast 3 Mile Lane.
Can you come up to the microphone and say that, please?
Thomas Siniscale, 4155 Northeast 3 Mile Lane. Number 42. And I am a constituent of this county. And when he says the lawyers are the problem, that is true. And if you don't realize that, you're not paying attention. The rest of my time, I yield to Bobby.
Thank you.
Thank you.
Thank you, Thomas. I've been on this path for quite a long time because my grandfather was very important here. My cousin was a senator. The Graves family are probably related to half of the Yamhill County today. They gave us free land. That's why they came out here. My uncle came out with the Donner Party, but instead of going down and dying in the snow, he came up with Applegate. Jesse was bringing people over the new trail, and he was the first one over that trail. With Mrs. Brown, if you've been to the state capitol, her name is right at the top of the list. She founded Pacific University with 6.5 cents. These people created a magnificent thing. And it can't be removed because somebody bankrupts it. You can't bankrupt what's not incorporated. Bankruptcy is the closing of the corporation. And you've all been incorporated when you were born. That's why your birth certificate is a bond paper. You've been securitized by the European fractional banking system called the Central Bank of the World. They run and own everything. And the Bar Association has a temple. It's the Middle Temple. There's 4 temples there on land that's never been England. William the Conqueror bypassed the place. He gave them a charter. They became a city-state. Templar Knights planted the Pope's flag. He owns it. Now it's the Vatican. They own all the law. They own all the money, and it's not money, it's just credit. The greenback dollar is not money, never has been. It's just a credit. And you have unlimited credit because Franklin Roosevelt gave you unlimited credit when he took away all the gold, which is money, and gave it to the Federal Reserve. So you have a trust, unlimited trust, and every single sheriff is supposed to be looking at that because every judge knows what he's doing when he puts you into a courtroom. He goes into your trust because you're in dishonor, because you did not redeem the bonds that he put against your case number that you didn't even know about. A bid bond, a performance bond, a payment bond. That's why you are, in fact, in incorporated legal fiction yourself, sitting right here. I'm not. I've done my paperwork all the way to the federal government. I own all my trade names. I don't have any trade names anymore. I own them. It's a very serious fine to use them without my permission. You need to know what's going on. It's your job to do that. I think Sam Elliott's probably a good man, but he's being deceived like everybody else.
I'm gonna have to
Been
ask
taken
you to wrap it up, Bobby.
Just do your job. That's all you have to do.
Appreciate it. Thank you. Up next, we have Ron Ruman. Name and address, Mr. Ruman, and you have 3 minutes.
Am I speaking clear enough?
I can hear you.
This is a petition for redress of grievance. We have 36 sheriffs on Oregon, and not one of them has a proper oath. Not one of them has fulfilled the obligations of ORS 206 and DPSST. And that doesn't seem right to me. Sam has gone farther than the other 35 in dealing with us and bringing forth his paperwork, but it's not right. And you have to understand that Article 7 amended in the Oregon Constitution is bogus. It's illegitimate. It's illegal. And I've been writing about this for quite a while, started in 2017. And since then, they have not been able to clean their act up. Doesn't appear they're going to. So now it comes to the county commissioners. You have a sheriff that cannot fulfill the obligations of his office. He hasn't done it in the time he's had. We've met with him. We've talked with him. Everything that we know how to do has been done. And we cannot get Sam Elliott to comply with what needs to be complied with for an Oregon sheriff. So now it comes to you. The county commissioners has a sheriff that will not comply, has not complied. So if you can fulfill your obligation to replace your sheriff because he cannot comply, then you will have done your job. However, you could refuse to do that also. And then you would be in the same position that Sam is in. Misprision of felony. You know, and you're in a position to change it and correct it and to make the situation right, and you don't. So that's misprision of felony. That's a position Sam's in. He knows and he hasn't corrected it. And he has all those deputies out in the street that aren't correct either. And they're all playing pretend in color of law. So now, is the Yamhill County Commission prepared to do their job? Or does it go from misprision of felony into accessory after the fact? You know that a felony has been done and you choose not to do anything about it. When do you become an accessory to that? I yield.
Thank you, Ron. With that, I see no other general public comment, so we're going to move on. Item E is department updates. There is none. F is work session. There is none. G is the consent agenda. Looks like we have some reappointments for the Board of Health Committee.
Chair, I move approval.
Motion's been made. Any further discussion?
None.
All those in favor signify by saying aye. Aye. Give that to me one more time, Commissioner King. No, still missed it. One more time. Or type it in the chat. I didn't. Okay, we got it. Thank you. Motion passes unanimously. Moving on to H, right at the very bottom. H1 is consideration of repeal of ordinance 945, not 943, a comprehensive plan amendment, zoning map amendment, and subdivision approval for tax lot R4418010000, planning docket number PAZ-01-24/S-03-24, and adoption of ordinance 944 for purposes of withdrawal and reconsideration pursuant to ORS 197.83013B. And how do you want to handle this, Caleb? We have a first.
Yeah, so, sorry, Mr. Chair, it's repealing ordinance 943. It will be ordinance 945. So we had that backwards.
Okay.
So, yes. Yeah, so, upon unanimous vote of the board, we can declare it as an emergency, and pass it today. And we have to do the first and second reading. So, if there's no objection, I can start with the first reading.
Do you need a motion?
No, just no objection.
Okay.
I have
I'll
no
need a
objection.
motion to,
No objection.
oh, okay. Do you need a motion before you do the first reading, is what I'm saying?
I don't think so, no.
Okay.
Nope, Jody says no. Okay.
Jody says no. Okay.
Okay. So I will begin the first reading by title only. In the matter of repealing ordinance 943, a comprehensive plan amendment, zoning map amendment, and subdivision approval for tax lot R4418010000, planning docket number PAZ-01-24/S03-24, and declaring an emergency. Is there any further discussion?
None.
None.
now I will begin the second reading. In the matter of repealing ordinance 943, a comprehensive plan amendment, zoning map amendment, and subdivision approval for tax lot R4418010000, planning docket number PAZ-01-24/S-03-24, and declaring an emergency.
All right. So with that, Jody, do you want us to take a vote now to approve that? Or are we good to go?
Yep, so the next step would be motion to approve.
Okay, make a motion to approve. Is there any further discussion?
None.
None.
All those in favor signify by saying aye.
Aye.
Aye. Okay, motion passes unanimously. Thank you very much. Moving on to item I is other business. Item I1 is consideration of adoption of an ordinance repealing and replacing Yamhill County Code Chapter 5.05 relating to ambulance service areas and emergency medical services, codifying the updated ambulance service area code and setting an effective date.
Chair, as you know, this has been a long, a process that's been in play for a while and many iterations. So I would move approval and thank the Ambulance Service Area Committee and our HHS Director for all the work with OHA.
I'm going to ask you to repeat that all next week. We're going to push this out one week just to get everything solidified.
Oh,
Correct?
Okay.
Yeah, just a few minor changes need to be made before next week. So
Okay.
just with Christian being out, there were just a couple changes to the ordinance that needed to be made. So we wanted to give you guys time to review that because I wasn't able to speak with Jody about it till yesterday. So.
And you're good with that, Jody, right?
Yes, and it's not, it's a formatting thing,
Okay.
Yeah.
Because there
not
was-
substantive, no.
We would have known about it. So thank you. Okay, yes.
Okay, appreciate it. Thank you.
Thank
All
you.
right, so we're going to move that one to next week. Item I2 is consideration and approval of a contract employment agreement between Yamhill County and S. Tim Simmons for accreditation, administration, and background investigation services in the amount of $45 per hour, not to exceed 20 hours per week, effective upon execution through June 30, 2029, with automatic renewal unless sooner terminated. I would move approval. Is there any further discussion?
None.
None.
All those in favor signify by saying aye.
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 Motion passes unanimously. Thank you. Item I3 is consideration of approval of personal services contract between Yamhill County Health and Human Services and Language Line Services, Inc. for language translating, interpreting, and testing services in the not to exceed amount of $250,000 retroactive to January 1, 2026 through December 31st, 2031.
Chair, I move approval.
Motion's been made. Any further discussion?
None.
None. All those in favor signify by saying aye. Aye.
Aye.
Motion passes unanimously. Thank you. Let's see. Item I4 is consideration of approval of amendment number 1 to agreement number 177708 between Yamhill County and the Oregon Health Authority Board Order 22-302, extending the term to December 31st, 2027.
Chair, I move approval.
Motion's been made. Any further discussion?
None.
None.
All those in favor signify by saying aye.
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 Motion passes unanimously. Thank you. Item I5 is consideration of approval of a board order in the matter of petition for road vacation RV-1-2025 to vacate a portion of a dedicated but undeveloped public right-of-way near Southwest Sunnyside Lane and Southwest Bright Ridge Road, Jiminy Christmas, sorry about that, Sheridan, Oregon, and adoption of a board order approving the vacation without a public hearing pursuant to ORS 368.351. I would move approval. Is there any further discussion?
None.
None.
All those in favor signify by saying aye.
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 Motion passes unanimously. Thank you. Okay. Item 6 is consideration of approval to submit a letter of support for the Yamhill County Development Corporation / Community Home Builders.
Chair, I brought this because we were approached and asked to support, as we have in the past, this project. Community Home Builders basically gets USDA loans and winds up creating many homes in various subdivisions throughout the county. I've been at several. What's interesting about this program is that they require not only it's income-based, but also that there has to be buy-in, and you have to go and build your home. And until everyone in the community in that development has finished, nobody can move in.
Oh,
So the impetus is on everyone to help each
everybody.
other get it across the finish line. And so it's pretty amazing. So right now they're working on 10 homes in Dayton, and they have to have 22 homes done in 2 years. The next one is in Amity, and their plan is to build 12 homes. So I think that these are wonderful, and they have been proven in our community. So I would move approval of this letter.
Fantastic. Motion's been made. Is there any further discussion?
None.
None for me.
All right. All those in favor signify by saying aye.
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 Motion passes unanimously. Thank you. Up next is item I7, discussion of TSP ordinance language. I have one public comment, and just go ahead and come on up, Jeff. State your name and address, and I just want to make sure that you know that this has been closed and it's still just discussion, so there is no more public hearing that is open on it. But go ahead and come on up. Yep.
My
Ni-
name is Jeff Kaiser. I'm a citizen of Yamhill County, Commendville for 80+ years. My comments are on the right-of-way that's been in discussion, and I've read the articles in our local newspaper, and they said the only comments you've had are from the positive, yes, we want it to happen. And I just have some questions that I wish to ask you commissioners that you're gonna have to ask your staff. Because I don't think people have any idea. I'm making some assumptions, so correct me if I'm wrong, but is this going to be under the county parks direction? The railroad right of way, bike path, whatever you're gonna call it?
Well, first of all, we don't, just make your public comment, but I will answer that. It is not parks. It is
So
transportation.
you don't want my comment now?
No, I do, but we don't engage with the back and forth.
Okay.
Just give your public comment.
The thing that I would like to see brought up in public is whatever department you're gonna have look after this and maintain it, what's this do to their budget? This is gonna be a whole lot different in maintenance and costs than just a normal 20 or 30 acre park in one location. My other questions are, besides the budget issue, are everybody's eyes open to, if this isn't a monitored entrance and exit, which I doubt if it will be, it's just gonna be an open use trail like a public facility. Cleanup is gonna be far more extraordinary than a normal park because it isn't just one spot, it's a continuous. I'm gonna mention some terms that I don't like to use in public, but they're truthful. You're gonna have urination, defecation, waste, etc., just regular trash, garbage discarded. Whatever's gonna happen, people are just gonna throw it off to the side and go about their business. The people using it don't necessarily have to be bikers. They can be walkers, they can be motorcyclers, they can be any number of things because it's open to the public. I feel sorry for the farmers that have to deal with the waste that's gonna come off this. And I think as it goes on, depending upon the time of year, the cleanup and the maintenance will grow by leaps and bounds, depending on how you want it maintained. uh, I don't know how else to say it. But I think it's a Pandora's box that nobody understands. To call it a bike trail, that's wonderful. But in reality, it's a public thoroughfare. You can walk, ride, bike, camp, any number of things on this.
I'm going to ask you to wrap it
My
up.
comment is, you better look at your budget dollars and what you're doing, because you're really opening up a Pandora box. Thank you
Appreciate
for
it.
your time.
Thank you, Mr. Kaiser.
Chair, just that, I'm wondering if we can get some contact information so we can share some information with Mr. Kaiser? So that we can share some information about what you just spoke about.
So we have address, but if maybe
Do you have an email address? Do you do
email
email
or phone
or a phone number? I think it would be good to have a further conversation. Thank you, Bailey. Thank you, Mr. Kaiser.
Okay, moving on. So we are on to item I7 and into the discussion of the TSP ordinance. Jody.
Sure. So this is, it's gonna be a very quick discussion. Of course, my voice goes away. I really, because we haven't presented a drafted ordinance to you yet, I wanted to make sure that everyone was good with the draft so that we could tweak it as needed before the first reading. So that was sent out earlier this week. So first I wanted to check to see if there's questions about the language, or if any additional language needs to be added to the ordinance itself. So I'll start with that.
Commissioner King, got any input on that?
No, thanks.
Commissioner Stewart?
Just a couple of comments. If you could clarify, Jody, a little bit about whether or not we would need to add an alternative pedestrian project to this.
Sure.
On a basis, but I did want to note that I was looking at the actual TSP and there were outlined proposed with cost with cost accountings, some pedestrian bike improvement projects. Would those also be able to be substituted for alternative projects if we needed to?
Sure. So that is the second piece of why I wanted to come in front of you today. I want to, so I know throughout the hearing, Chair, Commissioner, you repeatedly mentioned some various alternative projects. I don't know if, I did not include any of those here in this ordinance as optional alternatives. The only reason that we'd need to add some optional alternatives is if we don't, there's some OAR language that basically says, you need to make sure that you're still meeting the transportation needs whenever you do an amendment. So it might be good to call out some other priority projects. So I just wanted to lay the opportunity, because I know, Chair, you particularly had some other projects that you said, let's focus on these, and I just didn't get those down. So I'm wondering if you want me to add those to the ordinance.
Yeah, I don't mind adding those. Plus, I have a litany of other ones too that are going to be coming up here that we can add to. It's going to be from the George Fox presentation coming up in the next few weeks. So I already have that presentation. We can add those in there also.
Do you want to email me a list of those projects and we can present those at the first reading? And if folks want to add or detract anything from the ordinance, we can just do that via verbal amendment at that time. But this way I don't have to do, we don't have to do it 3 times then.
Yep, you bet.
Okay.
Do you want them just in the same format as the original TSP when it lined out from A to H?
That would be awesome. Yes.
It's a from, a to, what road it is, a need,
Yes.
improvement. Okay.
That would be super helpful. So the only other thing that I had, is I just wanted to clarify dates on it. So this will have to have a first and a second reading, 2 weeks apart. And effective date will be 90 days from the final reading. So that should put us around The findings will be done by the 26th board meeting. So that should put the effective date at June 10th, if all goes according to plan, of course. So I wanted to put that one out on the record so that it was clear when this would take effect. So that's all I had. So short and sweet, unless there's other questions.
So just to go back to that list of bike pedestrian
Yes.
improvements, would you like me to send you those so that you can incorporate them, or because they're already outlined in the TSP, would that suffice?
So what we'll do is, depending on the list that I get from the chair, it will be if they're not already mentioned, we will amend it in. If it's already mentioned, I'll call it out in the findings as this is a new priority project. So we'll have to finagle the language a little bit, but it will be, both are helpful to the ordinance.
Okay, I will just send you an email with just the pages so that you know what I'm referring to.
Okay, yes, and we will mark the ones that are already in there as new priority projects. If that's what the preference is.
Okay, thank you.
Yes.
Okay.
Okay,
Commissioner
All right.
King, anything else you want to add?
No, thank you.
All right. And Commissioner Stewart, I assume you're good?
I'm good.
Okay, we're gonna move on. Thanks, Jody.
Jody.
Item I8 is acknowledgement of Yamhill Soil and Water Conservation District's 2025 Weed Inspector Annual Report. No action is required. They just send it to us every year as one of their requirements. I just want to make sure everybody saw that in the packet.
Yeah, I appreciate their work. Yeah, they do a lot of sort of, they don't get a lot of attention and a lot of glory for it, but it's really detailed stuff, so appreciate it.
Yep. All right, moving on. Now that brings us to public hearings. And so I'm going to open up this first public hearing at 10:37. And it's consideration of a mass gathering permit application for the 2026 Memorial Weekend Boat Races event on May 23rd and 24th. Applicant is the Newburgh Boat Club Columbia Outboard Racing Association. I have a public comment card, Ken. Do we want to wait until we get through the presentation?
However you want to do it, I think it's not necessarily a land use application, it's state law.
Okay. So Don, are you going to be coming up anyway? You filled out a public comment, so just come on up and give your case, and then just make sure you touch on your comments that are at the bottom.
Don Schmidt, Newburgh, Oregon, 1604 North Meridian Street. And on behalf of the Newburgh Boat Club and the Columbia Racing Association, Outboard Racing Association, we're requesting exclusive use of Rogers Landing from Friday, 6 p.m. Friday evening until Sunday, the 24th at midnight. We're also requesting to be able to open up camping for racers that come down early on Thursday, the 21st. This will be our 78th annual event if we're able to put it on.
When you say if, weather related or? Yes, yes. How many years have you guys been doing this now?
Well, for sanctioned APBA racing, this will be our 78th year. But we have notes going clear back into the early 20s of racing from Newburgh to Salem and back.
Wow.
So it's been an ongoing thing for a decade or century. There is a couple of questions that we have on the board order that was put in last year. I'd like Doc Bailey to address one of them.
Okay, so, Bill Bailey,
1007 East Fulton Street, in Newburgh. There have been references to a graphic, Newburgh graphic notice to be placed. We would like that to be dropped. We're spending over $400 now, and the circulation of the graphic is just not where we need to be getting the terms out. We would like to change that over to notifications in Newsburgh. I don't know, I think they've been here and introduced themselves, but it's an online type news organization. And we would add a bunch of notifications in different social media outlets that refer to Rogers Landing also. And we're going to, you know, if we do that, we're going to be reaching a lot more people than we would in the Newburgh graphic.
I think we are required to put this notice in a publication of record. So I don't think there's anything that precludes you from doing all the other outlets online or whatever, but I think that we are required per this to put notification of this in order to grant permission for the application. At least that's what we've done over the years. But we also have waived everything except, we've waived the majority of the application fee, except for a small amount which would cover the newspaper notification. And so that's typically what we've done over the years.
Okay, it's just, if it's required, then it's required, but it's not getting the notice out that you want to get out.
Sure, yeah, the circulation in the Graphic and other local newspapers is certainly dropped a lot, but we, you know, however you want to get the word out, but we are required, I think, to post that in a publication. And Jody's nodding her head. So we've done that in the past. And the next question you would have is regarding the waiving the fee, except for, I believe it was a $250. Is that what you typically have been paying? And then the camping, that's something you've done in the past, right?
That is correct.
So it's basically rubber stamp. I'm thinking of everything we've done in the past years. And then except for the, well, in addition to the fee, which would remain, I would imagine, if the board agrees, that same basic, was it $250 instead of the larger fee? So that would be my recommendation if Jody and everybody else thinks we've got everything covered.
I agree with that. Commissioner King?
Yeah, I agree with that. Do you guys know how much you bring in on for your organization over the course of the weekend in fees and so on? Something I've been curious about.
As registration fees or as in outside fees?
I'm having a hard time hearing you, but really just what I think you're a 501c3, but really what you guys bring in your organization over the course of the weekend, whether that's, you know, merch sales or registration fees or camping fees or any of those types of things.
Just speak into the microphone, guys.
Thanks, Jody.
Denise Johnson from Columbia Outboard Racing. The fees vary year to year depending on how many people come in and register.
Mm-hmm.
The cost of the race right now is coming out about $12,000. So we try to raise at least that amount of money so that we break even.
Okay. And are you saying you're breaking even typically, or are you making money every year, or where is your books at?
A small profit, maybe not even more than a couple $1,000.
I would say we lose money a few years. We
Yeah.
make up to.
Okay.
It's not a money-making
It's not a money-making adventure at all.
Sure. Well, I appreciate you. I know I said last year that, you know, this brings in a lot of economic development in Newburgh and surrounding areas.
For the surrounding area, all
Sorry.
coming and staying at a hotel, they're eating at restaurants. So there is an economic impact in that respect, that we're
Right.
bringing hundreds of entries to the Newburgh area, and they are using the city of Newburgh or the surrounding area of Rogers Landing for food, gas, a hotel, so.
Thank you.
Fantastic.
Okay, thank you.
Thank you very much. Thank you. Appreciate what you do.
All right, so I would close this public hearing at 10:45. And any other further deliberation or comments from commissioners?
No, I would just, do you need a motion?
Yes.
Okay, I would move that we approve the mass gathering permit application for the 2026 Memorial Weekend Boat Races event on May 23rd and 24th, and with the allowance of camping starting on the 21st, and also waive the majority of the fee except for $250.
Fantastic. All right, any further discussion? Hearing
None.
all those in favor signify by saying aye.
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 Motion passes unanimously. Thank you. All right, that brings us up to our second public hearing. And I'm going to open that at 10:46. And I'm going to call for any abstentions by members of the board.
None.
Commissioner King?
I've known these guys for a long time. Hard to not know them up here where we live. So, but outside of that, no real conflicts.
Okay. I'm going to ask the parties if there's any objections to the jurisdiction of the board to hear this matter before it. Seeing none. And does the board need to announce any ex parte contact or any site visits to state on the record? I don't.
None from me.
None. Okay. Reading of the statement.
Oregon law requires that persons who attend a land use hearing be advised of certain rights and duties before the hearing begins. First, with regard to standards for approval, state law, ORS 197.797, requires that we list the applicable substantive criteria that must be met in order for the county to approve an application. The standards will be listed by a county planner in a moment as part of the staff report. Testimony, arguments, and evidence must be directed towards the standards for approval. Second, the raise it or waive it rule under Oregon law. Any issue that might be raised in an appeal of the county's decision in this matter must be raised before the record of this hearing is closed. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision makers and the parties an opportunity to respond to the issue precludes appeal to the board based on that issue. Third, and this is directed toward the applicant, under ORS 187.796, failure of the applicant to raise constitutional or other issues related to proposed conditions of approval, again with sufficient specificity to allow the county to respond to the issue, precludes an action for damages in circuit court. Finally, I will also note that under Oregon law, and because this is the initial evidentiary hearing on this matter, any participant, that is anyone who submits oral or written testimony during this hearing may, before the record is closed, request an opportunity to present additional evidence, arguments, or testimony regarding the application. The request must be made prior to the time the chair announces that the hearing is closed.
Thank you very much. And then that leads us to the staff report.
Thank you, Mr. Chair. The applicable review criteria and standards include the Measure 49 final orders issued to the sending and receiving lots identified as Measure 49 state election numbers E as in Echo 122333 and Echo 132440. The review criteria and standards provided in the Yamhill County Land Division Ordinance are also applicable. And staff report is as follows. The applicant is requesting partition approval for an approximately 37-acre property into two parcels of 2 and 35 acres. This request is being made using the Measure 49 Final Order and Home Site Authorization Echo 122333, which was approved by the Oregon Department of Land Conservation and Development. This request involves a transfer of the development rights granted by Measure 49 Final Order Echo 122333 from tax lot 3210-02400 to the subject lot 2323-02000 to facilitate the clustering of Measure 49 dwellings. The claimants for Measure 49 Final Order Echo 122333 were Catherine and Billy McGar. However, Section 4, Sub 7 of this Measure 49 Final Order states, quote, "This home site approval runs with the property and transfers with the property. This home site approval will not expire except that if a claimant who received the home site approval later conveys the property to a party other than the claimant's spouse or the trustee of a revocable trust in which the claimant is the settlor, the subsequent owner of the property must establish the authorized lots, parcels, and dwellings within 10 years of the conveyance. A lot or parcel lawfully created based on this home site approval will remain a discrete lot or parcel unless the lot or parcel lines are vacated or the lot or parcel is further divided as provided by law. A dwelling lawfully created based on a home site approval is a permitted use." Further, Section 4, Sub 9 of the Measure 49 Final Order goes on to discuss the clustering requirements and rights established under Measure 49, stating, quote, "Because the property is located in an exclusive farm use zone, Measure 49 requires new home sites to be clustered so as to maximize suitability of the remnant lot or parcel for farm or forest use. Further, if an owner of the property is authorized by other home site approvals to subdivide, partition, or establish dwellings on other Measure 37 claim properties, Measure 49 authorizes the owner to cluster some or all of the authorized lots, parcels, or dwellings that would otherwise be located on land in an exclusive farm use zone, a forest zone, or a mixed farm and forest zone on a single Measure 37 claim property that is zoned residential use or is located in an exclusive farm use zone, a forest zone, or a mixed farm and forest zone, but is less suitable for farm or forest use than the other Measure 37 claim properties," end quote. The subject lot that the applicant is proposing as a receiving lot for the development right is located in the exclusive farm use zone. And the lot that received and is sending the development right for clustering is also located in the exclusive farm use zone. The applicant made this request because the lot that received the development right and is sending it for a home site using the clustering option is located on a steep hillside, which may be highly suitable for forest use, but the steep slopes present on the lot could be a hazard for safe development of a home site. The subject lot that is being proposed to receive the home site development right through the Measure 49 clustering option has been used agriculturally in the form of a hazelnut orchard that encompasses the majority of the subject parcel. Additionally, adjacent parcels to the north, east, and south are located in the exclusive farm use zone. Neighboring lots to the west and northwest are located in the AF40 zone. There's a mix of farm and forest activities evident in the surrounding area, including grass seed and hay production, vineyards, nut tree orchards, and livestock pasturage and husbandry. Weaver Reservoir is located on the adjacent lot to the west of the subject parcel, and land use on this lot appears to be in forest use with a history of timber harvesting and replanting occurring in recent decades. And that concludes the staff report.
Thank you very much.
Thank you.
And that brings us to the applicant's case. Are they here? All right, come on down. Go ahead and state your name and address for the record, please.
My name is Mark Wilcuts. My address is 111 North College Street, Newburgh, Oregon. And I'll kind of go through both the sending and the receiving sites. We purchased them last summer at the same time. And at the time, we weren't really aware about the Measure 49 cluster. But as we got looking into it, just from our own research, we thought this would be a good site to do this on. The sending site is approximately 4 acres. There's 3 lots that were created under Measure 49. And is it okay to give you guys some pictures, or should I have sent that in earlier? Or?
Yeah.
Speak into the microphone, please.
Oh, sure. So I'll start with the sending site. So property's right back here. Circle. And it's approximately 3/10 of a gravel driveway to get down into here. It's steep, and then the fire life and safety, we've dug out an area where we can get one home site
So I'm going to ask you to just hold, if you can hold that in front of the desk real quick and just explain what you just explained to us so Commissioner King can kind of see it.
Okay, where
Ju-
should I?
The camera's right there at that corner, but just hold it right in front of your desk.
Okay. Hi, Bubba. Okay. Bubba, the driveway comes off Quarry Road, approximately 1 mile. It's a gravel driveway and it goes down. There's a circle here in the woods where the actual property is. This is a Hell's Canyon Road that hasn't been improved, but we'll be improving it.
Are you familiar with that area, Commissioner King?
I roughly know where that's at. Yeah.
Okay.
Okay, and there's some more pictures that
Thank you.
Thank you.
and those are, driveway, and you can see in the pages further on where we dug out the home side. And it's kind of a quick. And so, I mean, the real thing, it just doesn't make sense to, we can get 2 houses on there or 1 house on there we're comfortable with, but the other 2 lots, they would be very crammed in. I'll show you what we've, the actual plat map. And there's some more information on the wildlife agreement with that. The assessor's office, I guess it is. So we're in a special tax deferral where we can, if we maintain the habitat, get rid of the invasive plants, we put up bird houses, that type of stuff. So if we do build 3 houses on here, it's going to be a really tough in fire life and safety, and we'll lose all that wildlife corridor. That you can see in the pictures where we've been spraying and all that kind of stuff to maintain that.
Do you have any more handouts?
Yes.
Okay. Let's get all those because we're going to have to scan these and get them to Commissioner King so he can see them all.
Okay.
Sorry about that, guys.
I mean, no. Yeah. So, all right. Take this.
So in our opinion, if we built on all 3 lots there, 2 of them would have to be on stilts, the way it drops off. And so that's the sending property. The receiving property is a piece we bought about the same time. And at that time, we weren't aware about the ability to transfer those Measure 49 lots to another property. Originally, we were going to split it into 2 lots, a 2-acre lot and a 37-acre lot. We've done that. We want to keep it in farm deferral for tax purposes. We had, 4 farmers come up and look at it. They just said the logistics of getting their equipment up Chehalem Mountain on the steep roads and the gravel roads, winding roads down to the property just didn't make it feasible for them. We finally found one farmer who's willing to do it if we don't participate in any of the crop revenues. So he's taking all of the revenue, but we're able to stay in farm deferral. So there's just not enough land to make it viable for him to do that, or for other farmers to do it too. The orchard on it is an older orchard, or was an older orchard. It had blight in it. We let a farmer farm that this year. We didn't participate in any of the revenue. He was telling me that a good orchard produces around 1,800 to 2,000 pounds of nuts per year. He said this one this year was right at 800 pounds. And so we've gone in and we're bulldozing the orchard right now because it's got blight and all that. And he's going to plant probably grass seed or hay just so we can maintain the deferral, and he'll take all the income off of it. But that was the biggest thing. We just getting farmers to go up there and navigate those steep winding roads just made it not feasible. So if you have any questions?
I do. How old was that orchard up until you just tore it out? Do you remember?
Oh, I don't know. Mr.
Decades?
1964.
Old. Okay, thank you.
Yeah. Younger than me.
All right, Commissioner King, you got any questions? Mainly, we're trying to get you that stuff just when we come down to deliberations, but do you have any initial questions right now?
No, I'm trying to pull it up on Onyx as well, just so I can kind of have some understanding exactly where we're talking about.
Okay, Commissioner Sterrett?
No, thank you.
Okay, thank you very much.
All right, thank you.
Is there any testimony in support of the application? If you're online, raise your hand. Seeing none. All right, so that brings us to the appellant's case. Is there an appellant in the room? All right, come on up. Name and address, please.
Hi, my name is Malky. I'm an attorney for Mr. Robert Jennings, the appellant. I believe my address should be in the record, but it's P.O. Box 66562, Portland, Oregon, 97290.
I'm Robert S. Jennings, and the address is 21600 Northeast Finnegan Hill Road, Hillsboro, Oregon.
Thank you.
And I'd like to just begin asking if the applicant has submitted any additional written testimony that wasn't presented to you all just in person here today. I'm not sure. No, okay. And then I'll just begin. I'm not sure if you've had a chance to look over the comments that I sent in on Tuesday or not, but I'll quickly kind of go through and summarize the main issues with those. The most important one is that Measure 49 requires that the receiving property, in this case, be shown to be less suitable for farming than the sending property. And the applicant has not presented that evidence. I don't believe the criteria have been addressed by staff in the staff report, and I don't believe it's possible to demonstrate compliance with that criteria. And so for that reason, the commission should deny the application. And the reason for that is that the sending property is very steeply sloped. You heard that from the applicant. It's very small. There's been no history of farm cultivation on it at all. And it's also Class 6 soils. And if you look up the NRCS description of that class of soil, it says that cultivation is that's not what those soils are really used for. In contrast, the receiving property that is the subject property of the partition is Class 2 soils. It's high value. It's much larger acreage, 37 acres. And as you heard from Mr. Jennings, it's had a very long history of farm cultivation. And Mr. Jennings will speak a little bit more about some of the details of that and the qualities of the soil. But the main point is that the applicant simply hasn't met the burden that they needed to in this case, and so they cannot proceed with the partition because they haven't shown that the receiving property is less suitable. That's a major criteria for Measure 49. I think the clustering provisions were created as a way to preserve the more suitable farmland, so that if a Measure 49 claimant or owner who is authorized by Measure 49 has very good farmland, high value farmland, the incentive was to be able to preserve that farmland and to send that development to a different property that was less suitable. And here the applicant has it flipped. They're trying to send less suitable development from a less suitable property from a farming perspective to a much better farm parcel, and that's not allowed. The second issue I want to raise is the issue of ownership. It's kind of a technical issue, but Measure 49 requires that ownership be demonstrated by a deed. That's how they define owner in the statute and in the measure itself. And I don't believe in the record that there's ever a deed establishing the applicant's ownership of the sending property. So that evidence is missing and would be a basis to deny the application as well. Another point I want to raise on this issue is that there's another application for a partition on a different receiving property that's filed by a different entity. So the applicant in this application is Del Boca Vista. The applicant in that other application is Mesa Land, but they both rely on the same sending property. So that property that the applicant just described with the trees and he was showing you, as far as I can tell from the applications, they both use a sending property as tax lot 2400, and they're trying to send development from that property to different receiving properties. And the issue is those are two different owners. So Measure 49 says that if you want to do these clustering provisions, you have to show that you're an owner with authorization to do this. And in this case, if there's two different entities here, they can't really show that the same owner applies to both properties in both cases. So again, that's kind of a technical issue, but it's something that the applicant needs to clarify and has not clarified. And so without that clarification, the applicants failed to show ownership of both properties, and the commission cannot approve the application. Finally, another big thing is expiration. The applicant hasn't shown that they still have valid Measure 49 authorizations. And that is because those authorizations are valid for 10 years, and that 10-year timeline begins to run once the original Measure 49 claimant sells the property. So in order to determine when their Measure 49 order expires for either property, you need to know when the original claimant sold that property or conveyed that property to a new owner. So in this case, the one for the receiving property, I'll just call the Jennings Measure 49 order, that was, I believe, the claimant in that one was Nellie Jennings. But what we have in the record is that Del Boca Vista didn't buy that property from Nellie Jennings, the claimant. They bought that property from Robert Jennings, and I believe his wife. Pardon me, but I'm forgetting her name. But so they bought from someone different. So they need to go back, the applicant needs to go back and show, well, when did Nellie Jennings first convey that property to a new owner? Because that's what starts the 10-year timeline for expiration. And so if you don't know when the authorization is going to expire, then you don't know that you have a valid authorization. And so you can't move forward because the applicant hasn't met the criteria that they need to show. They need to show that they have a valid authorization under Measure 49 in order to proceed with these clustering provisions. And the same thing applies to the MAGAR Measure 49 waiver order, which is for the sending property. The MAGARs owned that property, received their Measure 49 waiver, but we have no evidence in the record of when the MAGARs conveyed that property. So for that reason, we don't know when the clock starts ticking. We don't know if the Measure 49 waiver order is valid for the sending property, if it's expired, if it's not expired, or when it may expire. And that brings me to another point, which is that the applicant also needs to demonstrate that they can accomplish all the things that they need to accomplish under the Measure 49 order before that order expires. So in this case, it would be the creation of a parcel, but also the establishment of a dwelling that would that would need to be demonstrated, or at least some evidence would need to be shown that it's possible to do all that before the expiration of the order. Otherwise, the authorization would expire and there's no ability to proceed with the clustering that the applicant's proposing. Another issue, and I believe I only have a couple more, is the issue of what these Measure 49 orders actually authorize. So if you're going to be sending something from the sending property to the receiving property, you need to show that the Measure 49 order actually authorizes the development that you're sending over. And so in this case, the sending property, which is the Magar Measure 49 order, the only thing that that order authorized is dwellings. It didn't authorize any additional partitioning of the sending property because the sending property was already partitioned at the time of the Measure 49 order. And so the way Measure 49 works is it never gave a claimant more than 3 parcels and 3 home sites. And so if you already had a property that was parcelized, the most Measure 49 could give you was the authority to build additional homes. So what's happened here is the order states that, and I cite that in my letter. So here, the Measure 49, the Magar Measure 49 order only authorized additional homes. So in this case, the applicant's trying to transfer the ability to create a new parcel and send that on the receiving property. But that wasn't what was contained in the Measure 49 authorization. So just to put it simply, if you don't have authorization to develop a new parcel on the property, then there's nothing to send to the receiving property. You have no authority to send that ability to a receiving property. And then finally, it's unclear to me, but it's not even clear to me that the applicant has the authority to build dwellings on the sending property because of the description that they've given, where they're saying that it's very steep sloped. It sounds like it's not practical and may not even be safe under Yamhill County's ordinances to build dwellings on those properties. And if that's the case, Measure 49 also has a provision for that. And they say that, for instances to protect, health, safety, and welfare, if a dwelling that was described in the Measure 49 waiver is actually not able to be built, then it can't be built. Because even though the Measure 49 waiver order says, yeah, you can build 3 dwellings on this property, if it turns out that it's not safe to build those dwellings or would not comply with local ordinances that, needed to demonstrate compliance with safety and welfare and things like that, then the Measure 49 order actually says that then we won't authorize any dwellings. And so again, if you're going to send something to another property, you need to show that under Measure 49, you would have had authorization to build that on the sending property. But they haven't done that here. So for that reason as well, I think their application fails and can be denied. Finally, just 2 other issues. Again, I talked about the kind of limits of Measure 49, saying that you can only get a maximum of 3 parcels and 3 dwellings. And so if there's already parcels on the property, then we're not going to authorize the creation of more parcels. We're just going to authorize dwellings. If there's already dwellings on the property, then we're not going to authorize, if you already have 2 dwellings on the property, then Measure 49 would have only given you 1 additional dwelling, because that's how that worked. There's a global cap on the amount of development that can occur. And if there's already been development, then that subtracts from what you're able to do going forward. And so in this case, because there are already parcels on the sending property, if the applicants are allowed to build another parcel on the receiving property, then ultimately you end up with 4 parcels between those 2, at least as far as this application is concerned. So that would result in more than what Measure 49 allows and would conflict with the statute and the measure itself. And so for that reason, again, I don't think that the applicant's proposal is allowed. In addition, I talked to you about that other application that's also using the sending property to send it to to send additional development to another property elsewhere in Yamhill County. That application, I think, is for 2 additional parcels. So if the applicant were to send 1 to the receiving property in this case, and another 2 to another property located elsewhere, not as part of this case, then that means that they'd end up with a total of 6 parcels. And again, that just exceeds what Measure 49 allows. You're limited to 3. And then finally, the last issue, which I believe goes to the suitability of farming for the receiving property, is just the location that the applicant has proposed for the 2-acre parcel that it's proposed to create on the receiving property. Under Measure 49, applicants are supposed to maximize the suitability of the remaining land for farming. And in this case, I think you've all seen the diagram of where the parcel is located. The property is kind of in a little bit of a panhandle shape, and there's already 1 parcel created at the bottom of that panhandle. And then this new parcel would be created kind of in the middle of the property. And it creates some weird shapes in terms of if you were a farmer and you needed to get access down, it's not ideal. And then I think also for me, the thing is that it's creating a lot more boundary with residential property. And I think, farmers try to be good neighbors. They try to be considerate of their neighbors. But when you increase that property boundary with a non-farm use or a non-farm residence, you end up creating more and more conflicts. Instead of worrying about, oh, am I going to, work on this area of my land on this day, you now have a lot more area that you have to consider your neighbors in how and when you're working and what kind of noise and dust you might be producing and things like that. So for that reason, again, the layout of the proposed partition just simply doesn't meet the requirements of Measure 49 because they haven't maintained the remainder property for maximum suitability for farming. So unless you have any questions, I'll leave it at that and I'll turn it over to my client. But basically, for all those reasons, the applicant hasn't met its burden in this case, and the appropriate thing to do is simply to deny the application.
Commissioner King, do you have any questions before we move on?
No, thank you.
Commissioner Stewart?
No, thank you.
Okay.
Thank you, Andrew. Thank you for allowing us to appear here this morning. I'd like to share some photographs and some text with you, if I may.
Thank you.
Thank you.
These pictures and text that they highlight the background and general suitability of the applicant's Finnegan Hill property for farming. The first picture on the top, number 1, the gentleman standing at the right in the upper picture is Andrew Orndorff, my great-great-grandfather who crossed the plains in 1862 and came to Oregon from Iowa. He is pictured with his hop-picking crew in 1902. His farm was just up the road from the applicant's property on Finnegan Hill Road. Andrew's nephew, John Malloy, is the little boy sitting in the front row just below Andrew. John became a farmer and had one of the first hazelnut
orchards in Oregon. John was the president of the Oregon Nut Growers Association, as was his grandson and great-grandson, both of whom are major players in the hazelnut industry. And they have Denfeld property and Laurel Food. They own Laurel Foods. John encouraged my father to plant hazelnuts, which he did beginning in 1964, just shy of 40 acres. It had been a productive orchard for many years. After my father died, my brother took care of the orchard as well as teaching high school. His health finally caused him to give it up. It was purchased by the applicant. In the second picture, my grandfather's dad's hop crew is shown in the hop yard circa 1915. Hops require rich soil, and many were planted on the north face of Chehalem Mountain. The applicant's farm ground is adjacent to where this picture was taken. The third picture is of my grandmother Winnie in the strawberry patch about 1960. My grandparents had 17 acres of strawberries. They were Marshalls and were well known for their wonderful flavor. I've been told there were at one time 1,600 acres of strawberries on the north face of Chehalem Mountain. I helped in the strawberry harvest and drove the truck a couple miles to where the Bird's Eye Cannery had a receiving shed. I think I was 12 or 13. This picture was taken on what is now the applicant's ground. The fourth picture is of harvesting black apps with the iron wino, which is what they call the machine, the mechanical harvester. My brother and dad are helping. Black apps have been a major crop here and in the valley for many years. They have an intense color and were used for many years to stamp the USDA on cuts of meat. They're currently used to add color to berry drinks and Chambord, a French liqueur. I raised black apps a few years and they were very, very productive. I made $5,000 an acre at one time. Many black apps have been raised on the applicant's ground. The fifth picture is of my wife and daughter standing next to some wheat I raised. It was called Malcolm, and it came close to 90 bushels to an acre, which is quite a good yield. This was right next to the applicant's property. The sixth picture is a picture shows part of the applicant's property when the orchard was young. And that's kind of to the right in the picture, with black apps to the left, then wheat or oats and strawberries, and more wheat or oats on the neighbor's property. There's over 100 acres in and around this picture that are very suitable for farming, well drained with gentle slopes. The last picture is of some Benton strawberries that my wife and I raised, and we sold them to a variety of grocery stores. My object in sharing these pictures and information with you is to illustrate just how productive this area is for farming. After the land was logged and cleared, it was rich in organic matter. I've learned from my own experience that it's still very productive if the time and effort is put in to add organic matter. Approximately 10 to 12% of the Earth's land surface is classified as arable or suitable for growing crops, while about 40 to 50% of that land is used for agriculture. The vast majority of that is pasture for livestock, not for growing crops. For well over 100 years, farmers on Chehalem Mountain have produced good crops almost exclusively without irrigation. We are blessed to live in the maritime Northwest and must protect our productive farmlands. if I can address some points that the applicant made.
Sure.
It's difficult. I've had trouble getting people to come up and help me with what farming I do. But it doesn't mean that the farm ground isn't valuable and that there aren't people that can make a living out of it. Part of the challenge with farming is that it's a lot of work and people many times shy away from it. But I think the ground has to be saved. We don't know what's ahead. We just don't know what's ahead, and we can't exploit the farm ground. Like I refer to the north face of Chehalem Mountain. Well, it's all a kind of a level plateau, and we called our farm mountaintop tablelands when we sold organic garlic at the farmers markets here and Beaverton. But the south face of Chehalem Mountain is steep and rocky. That's a great place to build homes, but not on that farmland.
Thank you.
Thank you.
Anything else to add?
Nothing for me, but I believe another person is going to come up and speak. Yeah.
I think it's all the same.
No, do you want to give him back?
Oh,
Okay, I'm Vidalia Twingy Jennings, and I reside at 21275 Northeast Finnegan Hill Road, a property adjacent to the subject property. I'm the daughter of the appellant, and I live in the house my grandparents built. Can everyone hear me okay?
Yeah.
Including Bubba on Zoom? Okay. As my dad stated, our family has farmed this land continuously for 7 generations. To live on and care for the same land that my ancestors have tended, loved, and protected for over a century means everything to me. Being raised in this tradition has defined who I am. It instilled in me the values of stewardship and a deep respect for the integrity of our resources. I was taught that we do not own the land simply to use it up. We hold it in trust for those who come next. Once you fragment farmland, you change the character of the landscape forever. However, we are not alone in this concern. Our neighbors stand united in opposition to this application. For those who could not give testimony today, I would like to lift up their voices with a brief summary of letters that have been submitted to the record, if that's okay. First, from the Joyce family, adjacent residents at 2605 Northeast Finnegan Hill Road. Lisa Joyce is the owner of an 80-acre commercial timber farm directly next to the subject property. She opposes this application because the proposed cluster development threatens her livelihood. She cites specific negative impacts, including increased fire danger, strain on water resources, and liability issues regarding the new residential use of an easement road intended for farm access, noting that her property insurance has already increased due to the land division that's already happened on the subject property. Her son, Bradley Joyce, and resident on the property, states that this proposal is a profit-driven violation of the law by the developer. He highlights the conflict of interest in home development funding county departments and argues that the subdivision has already altered wildlife behavior and will permanently remove high-value farmland from production. Next, Pam and Dirk Moritz, 29-year owners of 21,000 Finnegan Hill Road and adjacent property, voiced concerns that approving this would set a terrible precedent for significant change in our pristine rural area, prioritizing development over the community's low-density character. Next, Brian Ottaway, resident of adjacent property at 21800 Southwest Finnegan Hill, notes that he is personally a residential developer, yet he opposes this application because it doesn't align with the law. He echoes the legal objections raised by the appellant's counsel. Ornduff Road neighbor and lifetime resident Diana Takahashi emphasizes the short-sightedness of converting prime farmland essential for Yamhill County crops into dwellings. She raises critical concerns regarding our limited water area, noting that increased density will strain resources increase traffic and dust, and negatively impact native wildlife. Robert and Karen Hammond are residents directly across from the proposed access point who object based on safety risks. They cite dangerous traffic increases at their driveway intersection, heightened fire risk due to adjacent logging slash, and the degradation of the gravel road. They urge the board to uphold the original Measure 49 protections for agricultural land. Amy Larson, an immediate neighbor raising young children in the area, highlights the already dangerous state of local roads, specifically washboarding on Orndorff Road that forces cars into oncoming lanes, and warns that adding more drivers is a safety hazard. She also emphasizes that the proposed location next to timberland poses an unmanageable wildfire risk, recalling when the crews ran out of water during the Chehalem Mountain and Bald Peak wildfire in 2020. Victor and Christine Stymack, who farm Christmas trees and wine grapes on 135 acres adjacent to the subject property and own Three Feathers Estate Vineyard, argue that this proposal contradicts local zoning and opens the door for the developer to further subdivide what would be the remaining 35 acres. They identify 4 key threats: the precedent for further reduction in lot sizes, strain on limited water supplies, hazardous traffic on the dangerous and winding Finnegan Hill Road, and environmental damage threatening local wildlife such as cougars, bears, and a newly nesting bald eagle pair. Finally, Cassie Wyden, owner of Finnegan Hill Vineyard, a neighbor and farmer on Finnegan Hill Road, opposes this development and sees it as a threat to vital food production soils and the Chehalem Mountains agricultural legacy. She argues that further home development will drain precious aquifers and warns the community that the community cannot afford to lose fragile farmland to housing, urging the board to maintain the integrity of Oregon's land use laws. Cassie's daughter, Hannah Newman Wyden, age 10, also wrote a letter urging you to protect her home and environment for the future. She expresses a simple but powerful wish to keep the area rural with farmland and trees, stating that the city is in the valley and she does not want her community to become a suburban neighborhood. To conclude, whether you look at this from our perspective of a seventh generation farming family, a home developer like Mr. Ottaway, a timber farmer like Ms. Joyce, or a 10-year-old child like Hannah, our community is unanimous. In addition to posing serious risks and threats to the quality of life and well-being of our community, this application simply does not comply with the law. And we urge you to deny the request. Thank you for this opportunity to present our views. And I do have one more thing to add, because I noticed when Mr. Woods was talking about support from DLCD, I believe that you have in your record a letter that was sent from DLCD expressing the opposite view. So also urging you to oppose this. Do you guys have that in your record?
I have quite a few emails from DLCD, so
Okay.
you have to be
This
specific.
was sent on February 4th.
Yeah, and I can clarify. I think there were initially some emails sent by Matt Kroll from DLCD.
Yeah, I have October ones.
Yeah, and so I think, and then the applicant also in their application said DLCD is okay with this. That is not accurate. DLCD basically said in their February 4th letter that the applicant needs to comply with the criteria of Measure 49, and they specifically referenced the suitability criteria, meaning that the receiving property needs to be shown to be less suitable for farming than the sending property. And that's the exact same criteria that I referenced to you at the beginning of my presentation, that the applicant simply has not met, has not shown that they've been able to comply. And I, based on the record, they cannot comply with that criteria. As Mr. Jennings and his daughter have described to you, the subject property has been farmed for a number of different crops and is capable of being farmed for a number of different crops, not just grass and not just hazelnuts. Some of those can be very profitable if done right. and if the land is cared for properly by the farmer. And furthermore, that the surrounding area is simply much more suitable for farming than the surrounding area of the receiving property is much more suitable for farming than that of the sending property. If you look at a tax map, it's pretty easy to see where the sending property is located is very highly parcelized. Where the receiving property is located, there's much larger blocks of land and much larger farm operations and forestry operations going on around there. And so for all those reasons, even if you were just look at the soil of the property, but even looking at the surrounding of the property, all of those characteristics demonstrate that the receiving property is far more suitable and is the far more capable property for farming and even forestry if that wanted to be done there than the sending property. And so that is exactly the criteria that DLCD highlight in their letter, and they say that the applicant has not met those criteria, and therefore, for that reason, the application should be denied.
I have a copy of those letters if you would like to see it. The letter that was sent by DLCD on February 4th.
Sure.
We have,
Okay.
we have
Okay, just
received
making
things.
sure
Thank
got
you.
it. Yeah.
All right.
Okay,
Okay.
Yeah.
So,
Thank you.
so that's all from the appellants.
thank you.
Thank you very much.
Thank you. Chair, can we take a 5-minute break? 2
Sure.
minute-
Yep. Let's take a 5-minute break. Commissioner King, we're going to press pause for a second here. Try that one more time. Commissioner King, you there?
I'm here.
Okay, cool. All right, we're back from our recess and we're gonna proceed. So we are now to any other testimony in opposition of the application. I think we've pretty much been through all that. Now we're gonna go to public agency reports.
Thank you, Mr. Chair. The planning department received responses from the county sanitarian who noted that there are no identifiable conflicts with her office and that site evaluations have been approved for both of the proposed parcels. The Department of Land Conservation and Development responded to the county noting that an owner can cluster home sites only between two properties that have already had Measure 49 approvals under subsection 11, sub 4 of a final order, noting that the receiving property must be shown to be less suitable for farm or forest use than the sending property. And I think those are the October emails that were discussed. Subsequently, yesterday, the 4th, DLCD also submitted a follow-up statement comparing the suitability of both lots for farm use and also noting the quite steep slopes present on the sending property. They noted slopes of 30 to 60%. However, there was no comparison of the suitability for forest use for either property by DLCD on either lot. DLCD recommended that the county decline this request. The Soil and Water Conservation District submitted comments informing the property owner of the responsibility to comply with the Yamhill Basin Agricultural Water Quality Management Area Plan and a responsibility to control for noxious weeds. And that concludes the public agency reports.
Thank you. And at this point, we're going to have a rebuttal by the applicant if Mr. Wilcox wants to come back up.
So on the sending property, we are actually part of our wildlife, whatever it's called with the assessor's office, is to maintain forestry too, but it's in a wildlife deferral. But we have planted, or the previous owner planted trees, and now we're required to maintain them to keep that status. And then on the road that goes down is not an easement, it's a county road. When we did the first two partitions, we were required to build the road to county standards, which we did. And so it's not an easement, it's a county road, privately maintained. And then on the sending property, those lots are buildable. It's just, they're crammed in there, and it's not that we can't build on them. We just think it's not feasible to build on them. Plus, destroying the wildlife habitat there. So if you have any questions, I'd be happy to answer them.
Commissioner King, you have any questions?
No, thank you.
Commissioner Starrett?
No, just in terms of the latest letter that we got from DLCD, did you have a chance to look at that?
No, I did not, but I have had several conversations with Matt Kroll at DLCD. He's been through these before in Marion County, and he was very helpful in us getting everything together. And after my conversations with him, it was our impression that we were good to go with the Measure 49 transfers, as long as the county approved it, obviously.
Okay, thank you. I'm a little confused about the disparate, because there is, at some point, DLCD is saying they're approving it. And then the email we got yesterday referencing, I'm wondering, where the perspective has changed.
Where the disconnect is? Well, I don't know. I will say that I was in one of the meetings that Mark Wilcox was in, and I also had the impression that we were good to go. In fact, we had told Mark, no, you can't do this. And then he called the LCD and talked to them, and we actually had them come over for a meeting, and they told us how to go about doing this. And I'm not saying they approved it or anything like that. And maybe the higher ups are concerned about it for the reasons that they stated it in the letter. But I will say, Mark's right that at least my early impression was the same as his, that DLCD was okay with this.
Because the staff report references that. So that's typically kind of the bottom line, at least it is oftentimes for me.
Well, yeah, reference that, but after they, received other communications, I presume, from either neighbors or friends or whatever, I think they've decided otherwise. That's my impression now. And I'm not saying that they don't have the right to do that. And I should say, I don't know. I don't know what just made them change their mind. But again, in the meeting I was at, I sure thought that DLCD was saying that this was an okay thing to do. And again, we had said no, because I thought you had to have a identified receiving area, and they said, no, we changed that, took that out, and it's okay for them to, as long as they have two Measure 49 claims that they have agreements with, it's all right for them to do this, and here are the steps.
Because both were Measure 49 approvals, correct? This is really very confusing.
Well, as far as the deed question, are you wanting to leave the
Oh.
record open for getting that information in?
Yeah, we can leave the record open to get it. The sending property we bought in July, and that started the 10-year clock ticking on that Measure 49. And the receiving property we bought in, I believe, July also, or August. And so one of our due diligence was to make sure that we still had time in that 10-year window to move forward. So we can provide you deeds and all that kind of stuff, but we wouldn't have done this way if we didn't have all that information. We just didn't realize you needed all that. And one thing too that DLCD did was in a meeting after the one with Ken, showed us some property in Marion County that it had been done on. And so they basically helped us with our application and all that kind of stuff. So I'm not sure why yesterday's letter came in.
Can we do a little, I would recommend that you do a little bit more digging on that, because that's pretty important to this case, I think. Unfortunately, I don't like that DLC does that. They give you one opinion and then they rescind it based on information, especially the day before that we got to hear this. So if you're suggesting that we're going to leave it open already,
Okay.
then that may be one other thing that we get some answers to.
Sure.
Ken?
Well,
Okay.
Okay.
Yep.
Can you repeat that? We didn't hear it online.
My apologies. I was responding to there was a request.
Mr. Mulkey, what did you say?
Yep. Ken's going you want Ken, or you want Mulkey to say it, or Mr. Mulkey to say it, or you want Ken
Yes,
Friday to
I
repeat
think
it?
that's good for the record.
Okay. Come on up, Mr. Mulkey.
I guess
So for the record, I was just asking to hold the record open and to allow a response. And Mr. Friday said that they would do the typical 777 schedule. So 7 days open record, 7 days response, 7 days rebuttal.
Thank you.
Thank you.
All right.
Thank you.
All right. So with that, we just want to,
Yes, Mr. Chair, I can read the open record motion, and if this is suitable to the board, then you can just say so moved.
Okay.
The record shall be open to 5 p.m. on February 12th, 2026 for all parties to submit written testimony or evidence to the Planning Department at 400 Northeast Baker Street, McMinnville. The record shall then be open until 5 p.m. on February 19th, 2026 for all parties to submit to the Planning Department written rebuttal to what was submitted during the first open record period. The record shall then be open for the applicant only to submit final written argument with no new evidence until 5 p.m. on February 26th, 2026. At that point, the record shall be closed. The Board of Commissioners shall then reopen the hearing at 10 a.m. on March 5th, 2026 in room 32 of the Yamhill County Courthouse at the point of staff recommendation.
So moved. Any further discussion?
None.
None? Commissioner King?
None. Thank you for that. I was getting a little confused myself.
No worries. All those in favor signify by saying aye.
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 All right. Aye. Motion passes unanimously. Thank you very much. And with that, we're going to move on. Okay. So that takes care of. Where are we at here? J2. And we're going to move on to K, which is announcements. Commissioner King, you want to kick us off?
If it's all right with you, I'll skip this week, Chair. Thank you.
You bet. No problem. Feel better. Commissioner Sterrett.
Thank you, Chair. As we heard about the ambulance service area and the ASA plan, which we're going to hold off for another week, but we did discuss that at our meeting yesterday, and we gave an update on the fact that it is not technically, but pretty much materially a done deal. We also talked about engaging our paramedics and EMS in more of the deflection program that the county is doing and have more, because they oftentimes are the initial touch point. So that was a great meeting. Northwest Senior and Disability Services Board of Directors meeting. They discussed monitoring the appropriations bills at the federal level, because obviously there are going to be issues related to their service and their funding based on, for instance, Meals on Wheels, some of the family caregiver bills. So those are being monitored. The CCO Board of Directors meeting, we talked about procurement and the future of CCOs. There are, I believe, 16 CCOs in the state. What's going to happen? Are they going to be consolidated? Are they going to be, what is the future of how we deliver Medicaid? We talked about the changes, the eligibility checks, the work reduction, the work requirements, and the reduction in membership, which is going to really impact the Medicaid provision. Year-end financial year in review, and we talked about some of the rates. We had our meeting of the Family Wellbeing Council yesterday. We talked about, and some of the folks there are Child Welfare and HHS, suicide prevention in schools, and also want to call out some of the work that's being done by Reach Northwest for the foster community. They have foster parent night out. They have birth family gatherings. They have a resource advisory council. And I want to thank George Fox and Northwest Christian Church in Mac for some of the work that they're doing in helping with that. Building supports for new families was something else we talked about. I submitted testimony for the FFA funding, which Chair, I believe you will be able to give more detail on. Also, in recognition of AOC's 120th anniversary, Yamhill County will be featured next week on social media posts. Also, just an update from Sergeant Young in Emergency Management. As many of you might remember, we were holding on whether or not we were going to get funding for the hazard mitigation plan, which could impact whether or not if we have an emergency or we have a catastrophe or disaster regarding FEMA funding, but they are hoping to get an update soon. Also, for those who received from Gustavo, from Senator Merkley and Senator Wyden's offices, the community-initiated projects, that new grant cycle was opened on February 4th. So I contacted Sergeant Young and asked if, since there is a provision for emergency management if this would be able to be something he could submit a grant for. He spoke with the sheriff, and since there are sort of lots of needs in terms of the radio program, hoping that maybe some of those radio projects could fit the timeline for this SIP. Also had a conversation with a gentleman who is working with Oregon Housing and Community Services on a middle income revolving loan, which I'll be bringing more information to the board after we have discussions with our assessor and take a look at how we could perhaps look at that as an option in the county. Chair?
Thank you very much. Last Thursday, I had the privilege to go down to California to, I guess, pre-inspect buses that were coming off the line. We have 5 that are going to be coming to Yamhill County Transit soon. Very interesting. It's a Gillig Manufacturing in Livermore, brand new, fairly new facility. 40 buses a week come off this line. And it's interesting to watch actually through the whole facility that our 5 buses were at different stages throughout the whole facility. They really, when they take an order, so for example, I think it was Sacramento or San Diego Transit, they ordered 1,000 buses. Well, 1,000 buses don't get in line and then a next customer waits. What they do is they take that 1,000 buses and then they take Yamhill County, who has 5, and they actually rotate them in every single day. So by customer. So if we're behind San Diego, we still get our bus in the next line in this order of this whole train that they're building on this automated conveyor system. Absolutely phenomenal. But I'm also really into that stuff of production. So anyway, it was phenomenal. Cynthia's super passionate about our transit and our system and the way it works and those buses that she ordered. Stay tuned. Hopefully we'll have a convoy coming up with maybe save us some shipping rates. I'm really striving to do that. So let's see, submitted a letter for the 4-H and FFA programs yesterday night. My deadline is today. Just get it in by 4, but I'm pretty sure the deadline's somewhere probably around 5:30 today. Really passionate about it. I grew up through FFA, through high school. My daughter just went through FFA and did a lot of the programs. I think for me, I was a lot of the hands-on programs and a lot of the entrepreneurial programs that FFA offers. My daughter was more into the public speaking, which is good because I felt like I was always nervous public speaking, but now has that confidence that maybe one day she could be a county commissioner. I don't know. But I think FFA really, depending on who you are and what your personality is, there's a fit for everybody. You also have 4-H out there. You have any CTEC programs that are kind of in that realm for the kids that maybe don't really have college as their end result for life and want to go right into hands-on trade. The other, I think, very, very important part that FFA and 4-H programs bring to this county is for our Yamhill County Fair and the youth livestock auction. Just the money alone that those kids make off of raising their animals through all of summer and then reaping that benefit at the end by being able to sell it at the auction and make money to either put towards their project for the following year or college is huge. And it's a huge aspiration to them too to build their confidence. And then I think just the fact that the community comes together around at that auction to support those kids is great. And I can't say enough about the 4-H and the FFA. So if you do get a chance, please submit a letter of support for all of our programs. And there's a link on my Facebook page if you want to go to that, and you can submit to OLIS. There was Amity City Council last night. It's short and sweet. I know Mayor King, she listens to all of our meetings, so shout out to Mayor King. Good job running your meeting, very smooth. They discussed on whether to upgrade some of their railroad crossings. When the railroad's coming through to renew some of the tracks, they have an option to actually upgrade for a cost, and so they discussed that on 4th Street, possibly doing that. don't forget, chat with the chairs tonight at 6 PM at the Government Services Building. There is no planning commission meeting tonight. There's nothing on the docket. And Rod and Wyden has a town hall tomorrow at 5 PM. I think at the Armory, but double check that.
It is at the Armory.
Or at the Armory?
Yeah.
Okay. And that's all I have. We have no audience. They all bailed on us early. So thanks to everybody that's at the dais and online. We still have some online. And Jody.
Jody.
Thanks for coming, Jody.
Thank you, guys. I'm sorry I wasn't there.
Nope, no worries. Get well. Thank you. And with that, I'm closing it out.